Copyright. In our analysis of patents, we applied the economics of information to answer the two fundamental questions about breadth and duration. The same framework applies to other topics in intellectual property, notably copyright and trademark, which we discuss briefly. Copyright grants writers, composers, and other artists property rights in their creations on demonstration that their works are original expressions. Superscript 16, which reads, as Lord Macaulay put it, copyright is a tax on readers for the purpose of giving a bounty to writers. That's from Thomas B. Macaulay, Speeches on Copyright 25, open parentheses, C. Gaston, ed. 1914, close parentheses. Returning to the text. Unlike the patent system, the U.S. copyright system does not require creators to register their works in order to receive the protection of copyright. But very much like the patent law, copyright protection is limited in breadth and duration. The breadth of a copyright concerns the uses to which copyrighted material can be put without authorization. A broad copyright forbids any unauthorized use, whereas a narrow copyright permits some unauthorized uses. For example, books are quoted in reviews and satires, or photocopied or distributed electronically for educational purposes. The law handles these uses through so-called fair use exceptions. For example, in Sony Corporation of America versus Universal City Studios Incorporated, 464 U.S. 417, open parentheses, 1984, close parentheses. The Betamax case. The U.S. Supreme Court held that recording over-the-air copyrighted television programs on a videocassette recorder is fair use when done for time-shifting purposes, but not necessarily for purposes of archiving. The vague line frequently litigated divides fair and unfair unauthorized copying. Since its 18th century beginning, the United States has lengthened the duration of a copyright until it now stands at the creator's life plus 70 years. Superscript 17, which reads, in October 1998, Congress passed the Sonny Bono Copyright Term Extension Act, which lengthens copyright protection for works created on or after January 1st, 1978, to the life of the author plus 70 years, and extends existing copyrights created for hire and owned by corporations to 95 years. Before the change, the 1976 Copyright Act had given protection for the author's life plus 50 years. Whatever other reasons there may be for the Copyright Term Extension Act, one justification is that it brings U.S. practice into conformity with Western European practice. Returning to the text. The optimal duration of a copyright involves a different problem from patents, specifically tracing costs. Superscript 18, which reads, William Landis and Richard A. Posner, An Economic Analysis of Copyright Law, 18 J. Legal Stud. 325, open parentheses, 1989, close parentheses. And see also Wendy Gordon on owning information, intellectual property, and the restitutionary impulse, 78 va.l.rev.149, open parentheses, 1992, close parentheses. Returning to the text. Before producing her own copyrightable material, a creator may want to check to see if her ideas for a novel, say, are original. The cost of searching among all novels to make sure her idea does not unintentionally infringe on someone else's copyright can be extensive. To limit these costs, creators are given limited duration and relatively narrow breadth for their creations. However, the increasing ease of copying and spreading of literacy increase the ability of others to avoid paying the copyright holder a royalty. So the lengthening of copyright protection allows creators a longer time to recoup their just royalties. In some cases, copyright and patent law have extended too far and threaten to choke creativity. To appreciate the problem, imagine that someone obtains copyright to the English language. No one would be able to say anything without paying a license fee. This copyright would suppress language creativity. Similarly, many computer experts believe that fundamental languages should remain in the public domain where people can freely modify, adapt, improve, and use them. In this way, the Linux operating system has developed into a powerful programming tool. As we move away from operating systems to more applied programs, however, private owners control the most successful programs. Examples are Microsoft Word and Google. We could analogize operating systems to the English language and applied programs to novels. These facts suggest a natural boundary between open source and proprietary software. Computer programs hotly contest the proper location of this boundary. Their rhetoric can sometimes sound like a religious war of the 17th century or the bitter dispute between socialists and capitalists in the 20th century. The historical legacy of copyright law often hinders and obstructs communications among scholars and slows scientific development. Before the internet, scholars communicated mostly on paper when they did not talk to each other. Publishing an academic journal on paper is costly, so the publisher has to restrict access by charging high subscription fees. With the internet, the cost of disseminating journal articles plummeted. Yet the same academic journals, with their high subscription fees, dominate many academic fields. To change the situation, some scholars now refuse to transfer copyright over their articles to the publishers of journals with high subscription fees, or they reserve internet dissemination rights for themselves. An initiative called the Creative Commons attempts to create a new private copyright standard that guarantees for authors the right of cheap dissemination of their scholarship on the internet. Superscript 19, which reads, the Creative Commons, a project of Professor Lawrence Lessig of the Stanford Law School, allows authors, composers, and other creators to choose among a variety of protections for their expressions. See www.creativecommons.org. Back to the text. What is the future of copyright in the digital age? According to one vision of the future, most users of digital information will download it from a few large sellers who impose uniform charges. In this system, obtaining information resembles putting money in a jukebox to hear a song. According to the celestial jukebox model, see Paul Goldstein's book cited at the end of the chapter. Every user of digital information will resemble contemporary U.S. radio stations that must pay standardized royalties to a central clearinghouse whenever they broadcast a song. If the celestial jukebox succeeds, copyright will become the dominant law of the digital age. According to an alternative vision, however, copyright law will die because technology will make law unnecessary in the model of digital libertarianism. Technical protection through cheap encrypting will be more efficient than legal protection of intellectual property. Cheap encrypting will allegedly enable producers of digital information to control who uses it without much need for law. Are new laws the answer to new machines, or are new machines the answer to new machines? If you think you know whether the future will bring the celestial jukebox or digital libertarianism, then you should immediately go buy technology stocks. WebNote 5.4. Our website considers much more on the economics of copyrights, such as the recent legal controversy regarding downloading copyrightable material from the internet, constitutional objections to the copyright extensions of the late 1990s, further proposals for copyright reform, and a recent proposal by Judge Richard Posner and Professor William Lands for an indefinitely renewable copyright.